Good afternoon. Hi, 10 George Realty. So today is the conclusion, part 2 of the AIR purchase agreement. And we're very happy that you're here and learning with us. I learn every time I present this particular training. So what I'd like to do is we are starting on paragraph 10, where we left off at the end of 9. So I'm going to share my screen. We're going to get going on number 10. Okay. So I want to remind you, and I'm going to show you at the end of the contract pages, that on the purchases, on commercial purchases, you still are required to have a buyer broker representation agreement. CAR does have one that's exclusive. I mean, AIR has an exclusive one, and they also have a different form for non-exclusive. So at the end of this session, I will show you those two documents. Remember, they must be signed no later than the date per civil code that you're making the offer. So make sure that you're clued in and you remember that commercial purchases also require the buyer broker agreement. Okay. And I will show you those documents at the end. So if I'm looking down, it's because I have very extensive notes, so I don't wander off into the weeds. Like to keep it with information that will be helpful for you. So we're going to start with documents required, paragraph 10, before closing. 5 days prior to the closing date, the escrow holder is going to obtain an updated title commitment concerning the property. They're going to be obtaining that, shooting it out to everybody, make sure there was no changes. Remember last week I said in this contract, it defaults to a title commitment, which is a higher title report, if you will, than a preliminary title report. So if you do not want to have the title commitment, you needed to counter that. That's either on the buyer or seller side, okay? So they're referring to that title commitment report. So of course, this is like what we all know, like there needs to be the grant deeds needs to be signed, the FERPTA by the seller needs to be signed. And down here on 10.3, the buyer's going to bring in, of course, the cash required for closing. So I'm going to jump down to 11. Prorations and adjustments on 11.1. Of course, the taxes will be prorated through escrow as of the date of closing based upon the current tax bill that is available. 11.2, you see that big warning? It's about insurance. Any insurance which the seller may have maintained will terminate at closing, and the buyer is advised to obtain appropriate insurance. So as we always say, we're ahead of this because we started the day that this offer was accepted, making sure that the buyer is talking to their favorite insurance agent, especially on commercial. Get onto that quick with them, have them call around and check on the insurance. Okay. So 11.3, there, the proration and all of the things of rental, security deposit is prorated at close of escrow, if there are any. So these are pretty standard things that most of us probably already know about. I'm going to keep jumping to where I think it's more pertinent. So we're going to go to representations and warranties. So if you look at A through J, it's the seller warrant, stating that they're not aware of hazardous substance, any changes in the agreements. When you are on contract in a purchase, if you have tenants, you can't just go and change agreements without consulting with the buyer, nor can you go ahead and just lease a vacant unit. You need to consult with the buyer if that unit was vacant when they made the offer. So things of those natures, changes in agreements, mechanic liens. So the seller's stating that they don't have any knowledge of these things. But I want to call your attention to 12.1 at the very top. You see, there's a limit on I guess for suing, and Peter's better to explain this type of thing, but seller warranty and representations shall survive the closing and delivery of the deed for a period of 3 years, and any lawsuit action based on them must be commenced within that time period. So there's two schools of thought. Some people want to make it longer if you're a buyer's rep, or maybe the seller wants to make it 2 years, or maybe they just leave it. But put a little star by that paragraph so you understand the limitation is 3 years. Okay. So I'm going to move down now to 12.2. This is your as is paragraph, if you will. So paragraph 12.2 is the buyer is acknowledging that they're buying this property in its current present condition. Of course, the seller would still need to do their normal disclosures or disclose any material facts on the property. But this, if you can put a little star by it, this is your as is paragraph 12.2. 12.3, in the event that the buyer learns a seller representation was false and the buyer still proceeds on and purchases the property, then the buyer waives the right to sue the seller after closing on that representation because they already knew it was false and they proceeded to closing anyway. Okay. So 12.4, seller will provide any environmental reports, things of those natures that they have in their possession to the buyer. Those are provided for convenience sake only, and they're not making any representations as to the accuracy of those third-party reports. So they will supply them as a convenience, and it's telling the buyer to go ahead and work with their own people to verify such reports. It's nice if a buyer has phase 1 reports from the seller from previous. They may still do their own, but it's good as disclosure. So, but don't rely on a third-party older report. You need to inspect it for yourself. Yes.
Michelle, the possession, shall we mention at the same time the property to be vacant at the time of loss of residence?
Okay, so possession's a little tricky. It depends, right? Are there existing tenants under existing leases? Or even if they're month-to-month tenants, we can't guarantee that will be delivered vacant. If it's a one owner operated warehouse, sure. But I don't know that you can say that it can be delivered vacant. Peter may have more opinion on that if there's an existing tenant, whether it's month to month or not. It's not that simple.
Yeah, you don't have to disclose it. I don't think you
Because sometimes they say,
Every time if you want to deliver vacant in the deal killer.
Yes.
you better to specify the property to be vacant.
No, they
Not
can't.
necessary.
Well, you can't if they have existing tenants.
If they have an existing tenant, you have to use it. I can represent that it's vacant.
No, he said that he wanted to counter that it would be delivered vacant.
Deliver, yeah, exactly that. But it's a negotiable.
Mm-hmm.
It's totally negotiable. That whether they will agree to that or not, it's up to them.
Yeah. And you would presumably, you'd be looking at the leases, right? So, you have to look at the term of the leases and all of that stuff. Yeah.
So Michelle, for the phase 1, phase 2, who's supposed to pay for it?
Negotiable.
Negotiable.
Oh, yeah. Everything on that is negotiable. Yeah.
So, would the seller to have those reports handy?
No, not necessarily. That paragraph I was referring to only says if they have them in their possession, they're going to provide them as a convenience. but that you don't rely on that old report from a third party, that you can get your own inspection on anything like that. But no, it doesn't mean they're going to have it. You know, we've been through a lot of transactions where the seller didn't have an old phase 1, phase 2.
Yeah.
Now, you only go to phase 2, mind you, if phase 1 recommends it, right? So, yeah. They'll provide you what they have, but they're not required to if they don't have it, obviously. Yeah. So on paragraph 14, and this is a shorter training today. We did most of it last week, so we'll have a lot of extra time. So the buyer's entry: at any time during the escrow period, the buyer and its agents or representatives have the right at reasonable times and subject to the rights under the tenant to enter the property for inspections, tests, etc. No destructive testing is permitted though, unless the seller consents. Okay, so that's pretty standard. We know that type of paragraph. So further documents and assurances.
No, before you let the buyer goes to premises, make sure they have the right insurance, liability insurance. Especially when they have to do something.
Oh, the inspectors? Are you
Not the
talking?
inspector, the buyer,
The buyer has to have liability.
yeah.
Oh, okay.
If you want to go in and do anything, you know, make sure that they have the liability insurance to cover them.
So Peter said if the buyer's going to do anything on the property, you know, prior to them owning it, then make sure that the appropriate liability insurance is in place.
Most buyers are aware of that they.
No, they don't, you have to, it's okay then.
So we have to tell them.
Yeah, you have to have.
If they say where and how do we get liability insurance?
Talk to your insurance agent.
Insurance agent, okay, so it doesn't have to be a specific.
No.
Okay, perfect, that's good to know.
Okay, further documents and assurances, all parties are going to take reasonable steps to execute and deliver all documents for closing. Attorney's fees, you can read the whole paragraph, but the prevailing party, the losing party will pay reasonable attorney's fees to the prevailing party. So I don't know what reasonable is or what amount that would be, but that's basically the meat of that paragraph, okay? So prior agreements and amendments on number 17. This is the entire agreement. It's, you know, whether, you know, whatever you talked prior to being on contract, this is your entire agreement. We're not relying on chit chat before it was on contract. This is it. And of course, any amendments that pertain to the contract or were attached to the contract. So broker's rights. This is kind of an interesting paragraph. So broker's rights, if this sale is not consummated due to the default of a buyer or seller, the defaulting party shall be liable to and shall pay the broker's commissions due. So if the buyer defaults, it would be in addition to the liquidated damages if that paragraph is applicable. Okay, so they've built in some protective paragraphs for, you know, for the brokers. So that's a good one to be, you know, aware of for yourself.
So in case buyer default, then they're eligible for agents.
They're liable, and you know, the contract says they're liable for that plus their liquidated damages should that have been applicable.
Liquidated plus the agency.
Yeah, only if, liquidated damages must be applicable though, and I'll show you that paragraph. So notices, I'm not going to go over that too much, but here in 19.3, they do allow for you to add or designate a different address where you want notices delivered to, or amend the people that are being notices. So on the communications during escrow, so you would notify all parties that you're adding or subtracting someone. So 19.3. 20, the duration of the offer. So on this particular one, we need to put the city. I would also recommend putting, if it's, you know, like Alhambra, California, I would want the state there. So if this offer is not accepted by the seller before 5 p.m. according to the time standard applicable in the city of Alhambra, California on the date of, and then insert your date here, it shall be deemed automatically revoked. Okay, so it's just a, duration of the offer that we're probably pretty familiar with in all of the other contracts that we deal with in real estate.
Usually how many days?
It depends, right? If it's something they really want, I probably wouldn't cut them at the knees real quick, but if it's multiple, I think we usually give about 5 days. But if you think it's multiple and there's more and you feel like you need to give them less or more, go ahead. But generally we give them at least 5 days because you need to get it over to them. This is a big contract, we're only going through portions of it. So the agents and the seller needs time to review. So I wouldn't want to revoke it quickly,
CAR is 3 days.
Yeah. Yeah. So 20.2, let me see. The acceptance of the offer and counter offers shall be deemed made upon delivery. So that the acceptance of this offer, shall be deemed done once you deliver to the other party the contract and any amendments or counter offers. So 21 is really important in this contract. So I would really, put a star by it, remember it. So this is liquidated damages, and it's only applicable if initialed by both parties. Now, as we always say in our training, there's a cap on residential 3%, right? But liquidated damage is not capped in commercial. So here you can put an amount in, say, I think on one of ours, we just put in 20,000. I can't remember, something like that. So we put in liquidated damages here for, that's what the buyer wanted to do. And then upon payment of said sum to seller, buyer shall be released from any further liability to the seller, and escrow cancellation fees and title company charges shall be paid by seller. Okay. So remember, if you buyer's agents, if you send this over with the buyer's initial and your amount in, and you want this to be applicable, make darn sure that you're getting back one initialed by the seller, because it's not going to be applicable if you don't have both initials. And if that's what your buyer wanted, make sure you get it back. Okay. Arbitration of disputes. Again, this is only applicable if initialed by both parties. So you initial here and here. If you are, now you can initial liquidated damages without initialing arbitration of disputes. That's up to what the buyer wants to do.
The arbitration process, usually people wants to have arbitration because they think that it's cheaper and takes less time. But nowadays, not necessarily true, because the arbitrator is very expensive. Arbitrator charges about $800 to $1,000 per hour. Per hour.
I thought that each case is like a 1350 on CAR.
No, this is commercial. And most of the commercial, they want to get a jams. You see, remember that in the arbitration, there's a jams, services, judicial arbitration and mediation service. They are very expensive. Those arbitrators are very expensive.
How much?
They are retired judges. And they charge $800 to $1,000 per hour.
Yeah.
And it can easily cost you like $100,000 just to do the arbitration. While if you go to court, the judge is free. You don't have to pay for the judges. You just have to pay for the attorney. But even in the arbitration, you have to pay for the attorney too.
Oh, wow. So
Yeah,
you're getting
and-
double hit.
Yes, and arbitration is a little bit quicker, but most of the lawsuits get settlement and mediation anyway. So sometimes it's cheaper to just go right directly to the litigation than require you to do arbitration. So you think about it, not everybody is not a mandatory thing.
Oh, okay. So we just did that and we only signed on the liquidated damages.
Yeah.
And then we didn't want to do arbitration. We didn't have the buyer, we explained it, they did not want to sign it. So we just did the liquidated damage.
And also for the attorney fees, like we, on Wednesday, we saw the eviction lawyer saying that, hey, not necessarily, it's an attorney fee, which is not necessarily good for the landlord who steal a pocket,
Yeah.
the same thing
They're
here.
gonna go after the man.
Yeah, same thing here.
Yeah.
If the tenant doesn't have anything, when you sue them, even if you win, you're not gonna collect. But the landlord, for sure, he has the property there, and they can put a lien on the property, right?
Wow.
So this kind of thing you have to think.
Yeah. Yeah, because you kept saying that, Peter. That's why we moved away from it.
Yeah.
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 On the arbitration.
Guaranteed, right? That they say, things are what we do. I mean, even, not guarantee that person's gonna abide by that, right?
No, it's a binding.
Oh, it's
Arbitration is binding arbitration. Mediation is not.
Okay.
But you see, when you check that, you do mediation.
I don't
and
know, but you're still
arbitration.
paying a lot of money
It's
per
more
hour.
expensive.
Can people allowed to not agree with the result from arbitration?
No, you agree, when you sign this clause,
You have to
arbitration,
agree.
you already agree, this is by contract, you agree that,
Whatever they say.
yeah, it's a binding for arbitration.
Oh, yeah. Wow.
Otherwise, it's not, then, it's no different from mediation. Why do you have to go through arbitration then?
Mhm.
If they, usually you go through the mediation first,
Right.
and if the mediation fails, then you go arbitration. It's a binding arbitration,
So that's the final
that's the
decision.
final, because you want to avoid litigation. That's the whole purpose of signing arbitration.
Wow.
And if you don't want it, you just say, forget it, I don't want to sign the arbitration clause, I just want to go directly to litigation. You have the right to do that,
Yeah.
It's cheaper.
Litigation meaning,
it's cheaper. Huh?
litigation meaning.
Lawsuit,
File a lawsuit.
regular lawsuit, yeah,
Oh, that's called a litigation.
yeah.
Yeah.
Non-arbitration meaning litigation.
Yeah.
Right, you don't want to go arbitration, that means you want to go
It's either one,
straight to lawsuit,
it's either one, either arbitration or litigation.
right?
So we're
Interesting.
in the miscellaneous. I'm only going to point out a few things that I think you should be aware of, that this agreement is governed by the laws of the state in which the property is located. So if it's an out-of-state person making an offer, it's going to be governed by where the property is located, okay? Not where the buyer may reside or anything like that.
So that's why I have to put down the city.
I put this, I don't like just the city, I like comma the state. I like the
Oh.
state, but that's just me. So if there's any conflict I'm on 23.6 between the printed provisions of this agreement and typewritten or handwritten provisions, then it shall be controlled by the typewritten or handwritten provisions. And when you do that, the seller or the buyer must initial all typewritten or handwritten provisions on this agreement. That's really hard to fit it all in. So you might want to just do an addendum rather than handwriting on the agreement. If it's something small, you could probably fit it, but I don't recommend it. It's hard for people to read sometimes unless you typewrite it.
Michelle,
Yes.
so that means that, letter of intent shall be signed or initialed by buyer or seller?
No.
No.
No, letter of intent, you should always have your little non-binding paragraph at the bottom. And there's two schools of thought. I think it was an AIR attorney said, do yourself a favor, don't ask your buyer or seller to sign that letter of intent. Just sign as the agent on behalf of, blah, 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 but don't put it, blocks in there for them to sign it. Don't do that. Because I think something came up years ago where a seller actually did sign it. And even though it had the little blurb non-binding, there was still like a scuffle on it. So because I watched that training, don't ever put on your LOIs for a buyer or seller to sign it. Of course, you're going to email it to them and say, hey, Mr. Buyer, here's the letter of intent I'm going to present on your behalf. Do you require any changes? Right? And you have your little non-binding disclosure, but don't ask them to sign it, is what their advice was. So I just listened to them.
Yeah, and you always include a clause that say that it is non-binding and it will be followed by a formal purchase agreement
Yeah.
from the seller.
And
Like
make
a
sure, yes, good one. And also expire it.
Yeah,
Expire that LOI, write in your non-binding, and this letter of intent shall be valid until,
Yeah.
and expire that thing. Don't leave it open forever, okay? So on 23.7, the 1031 exchange is already built into the contract. They built that in already, so you don't need to mention it. It may be as a courtesy you do, but they took care to build this into the contract that the buyer and seller, should either one need a 1031, will cooperate with each other, okay? And then in this contract, just so there's no misnomer, days in this contract shall refer to calendar days, okay? So disclosures regarding the nature of real estate agency, they've built that in. Please, when you write these though, always have your agency disclosure on top, please. Don't forget to do that. You must have an agency disclosure.
This is the one, the first page.
No, AIR, like we do with car, you must have an agency disclosure. And that goes for leases and purchase agreement through AIR. Additional provisions, sometimes people miss this. Write none in here if you don't have any. It's instructing you right here that if there are none, put none. Okay, but if you're going to attach an addendum with some additional provisions, put the paragraphs in here. Maybe it's paragraphs, A through Z, or, that's exaggerating, but whatever, you can name it paragraph A through G or whatever. Okay, but make sure that you put none if there is none, so they're not wondering if there was any additional attachment on that stuff. It's just nice for the listing agent, so when they're reading it. Now, this is there's a warning here that all parties shall seek the advice of counsel as to legal and tax consequences of this agreement, and that the parties will retain appropriate consultants to review and investigate the condition of the property. So that's nice here that they've put that in big bold. And if either party is a corporation, the AIR does recommend that the agreement be signed by 2 corporate officers. That's just their recommendation, okay? So there's one very, very important, the most important. I'm going to come down here. So this is all going to be filled out and signed here, 27. This is where you put your commission. So if you look at 27.2, in consideration of the real estate brokerage service rendered by brokers, seller agrees to pay brokers a real estate fee in a sum equal to, 5%, so we'll go with that, of the purchase to be divided between the broker as follows: seller's broker 2.5, buyer's broker 2.5, or 3 and 2, whatever you put in there. And this agreement shall serve as an instruction to escrow holder to pay the brokerage fee to brokers. So this is really important. I know that it's easy to miss because it's tiny, but make sure that you're always aware of where the commission is here. The seller acknowledges receipt and a copy of this and authorizes the broker to deliver the signed copy to the buyer. So once you receive this, they've already authorized you to go ahead and deliver it. Okay, so today is shorter, but I am going to show you the broker buyer agreements for representation. And before I move on to those forms, is there any questions on Zoom or in the room?
I also want to mention that most of the commercial leases, with the entity, you know, the tenants of the entity, a corporation, LLC, and most of the corporation entities are newly formed entities, you know, you don't have that much assets. So most of the time, very important, and for the landlord is that you have to get a personal guarantee, you know, for somebody,
Yeah.
you know, who has a net worth, you know, worthwhile net worth. So that in case the corporation before the bankruptcy, you still get you know, block that the person. Very important.
Excuse me, Michelle. At the bottom of each page, there's a place, both sides, there's a place for initial.
Yes.
So who initial on the right, or who does it? On
Good
the
question, Christine. So how I do it is, okay, so this isn't delineated that way as the leases are. So usually the lease has the buyer and the landlord and the tenant on one side. So I follow that. But in the case of on page 11, they have the buyer and the seller on both pages. So I would probably put the seller on the first block. Yes. Yeah, on the right.
Seller on the right-hand side.
I mean, no, I'm sorry. On my other right, I would do it I would put the seller first
Okay.
here, the initials here, and then I would do the buyer
Yeah.
over here.
Each page.
Yes, each page must be initialed. That's correct.
So seller initial on the left side.
Now on the AIR leases, it'll be tenant and landlord each on one side. So I make the initials for that party on that side of the contract. But this one they're all running parallel.
They're always.
Yeah, you like to put them first. Always put them first on the initials. Okay. So I'm not going to go line by line over this, but I want to show you the buyer broker exclusive, and they also have one for non-exclusive. This is required, folks. This isn't something that we can say, oh, we don't want to do. No, it is required for purchases. So it's pretty simple to fill out. Property characteristics, what you're helping them purchase, things of that nature. And I want to get down to the compensation. So this is 3 months. You can only have this agreement for 3 months. Okay. Here, I didn't give it to you because I just thought of it. Compensation is located on paragraph 1.8. So you're going to check for the percent. You're going to insert the percent here of the property's purchase price. Okay. Or whatever. Okay. And then here on 1.9, I want to point this out. Here's the compensation here. Seller to pay applicable if only check. So you have two choices here. The broker and buyer intend for the seller of the property to pay 100% applicable only if completed of broker's commission. So 100%. So if you want that to happen, if you want to check that box on behalf of your buyer, make sure that you're going into 1.8 and 1.9. Okay. Fill out both of these boxes. Of course, you're going to fill out the whole form, but I just wanted to get to the compensation one. Okay. So make sure that these two are completed properly. If you are in a transaction, we'll go over these with you at that point. If you need help, Peter or I will certainly look at it for you. And there is also a non-exclusive. Hopefully you always get exclusive, but if here's a non-exclusive. Okay. So I will make copies and blast these out to you just so you can review them in case you do get into a commercial transaction purchase. So I will send those out to you, but just make sure that you're not having those signed any later than when you're making the offer. Do you,
Letter of intent.
letter of intent is not required?
Oh,
No. Letter of intent is a way to negotiate to see if you guys have a meeting, you know, can get pretty close on terms, right, Peter? It's not a required document. You could go straight to offer.
Yeah, it's a preliminary negotiation, not binding.
oh. That's why Michelle just said, both parties not recommend to sign.
No, you don't have to have both parties sign the letter.
Right, right. And she recommend not to be
Yeah,
signed.
just use the, you know, you
And
have your
the seller. will
your
be
agent to represent you.
Well, even though it says non-binding, when I was in that training, they said, don't put the buyer, you know, don't put the signatures on it. There's no reason. Just put on behalf of, you know, blah, blah. We submit the following terms and conditions for your consideration.
Yeah.
Okay, because you know, yeah, it's best not to. We don't do that. Shumay and I we don't put signatures on it. Only her signature that she's submitting it on behalf of. Yeah. Does anybody have any questions? It's on Zoom. Okay, so I'll send out those, the buyer broker AIR agreements for your review. And then if you need any more in-depth going over those, because I just thought of it at the last minute, then we can, you know, you can come talk to me or Peter. But I will e-blast those out today so that you have a copy of them for your retention. Okay, any other questions? Oh, quiet. Okay, well, we hope to see you at 3. We're ready to party and have good conversations and lots of fun and food. So
Oh,
thank you
Michelle,
all.
Michelle, it's Rebecca.
Hi,
I missed,
Rebecca.
I missed last Friday and I just tuned in. I got home right now. Are you gonna go over this again? Any other time?
Well, we're on a wheel, you know, so it
Okay.
does pop back up. However, this is recorded.
Okay, good. Okay,
Yeah,
then.
and we posted it on our YouTube account.
Okay, good. Thank you,
Yeah.
Michelle.
Oh, you're welcome.
Okay.
All right, then I'll wish you all a good weekend and see you all at 3. And if you have any questions on the purchase agreement, the AIR or anything, me and Peter are available to help you with any of your questions, okay?
Thank you.
Thank you all.
Thank you, Michelle.